Hi everyone, welcome to ArtsFest Online and to this afternoon's workshop, Inspiration or Imitation, Copyright and Moral Rights in Artistic Works with Dr. Metka Potočnik. This is the first in a series of 5 workshops that will cover intellectual property in the arts. If you have any questions as we go along, please do shout up during the presentation, otherwise you can use the chat. And just a quick reminder that this is a public platform and the session is being recorded, so please don't share any confidential information. Welcome all, it's really lovely to have you this afternoon with us. Over to you, Metka.
Well, I think both Claire and myself, we were very keen on making this a nice, friendly environment. And currently it's the two of us are showing our faces. So if you feel like you want to sort of be in a room together with us, especially for this beginning, and then later on when we have some questions as well, you're welcome and invited to share your cameras. You don't have to, but if you want to, you're welcome to do so. But we would invite, or I would be very keen to hear, at least in terms of the types of works you do. So what are your creative practices? Are you into painting, sculpture, photography, installation art, something in the middle, interdisciplinary, whatever it is? And if you want to sort of just unmute yourself and speak to us, that would be awesome. If not, maybe if we could just invite everyone to put a sentence or two in the chat and we could sort of just know a little bit around who's in the room. Because I'm from the law school, I don't recognize all the names. I can catch a name here and there because I've sort of crossed paths with some of you, but not many. So it would be really helpful, I think, to sort of have a chat with you all. So if you're willing to do that, we would start the ball rolling. Hi, Helen, and Helen is a photographer. Excellent.
Anybody else? Okay, oh, Denise is fine art. Rachel, no Rachel. Hi, Rachel.
So I would also like to say to everyone, today is a longer session and it's meant to be a longer session so that we chat with each other, not that I get to speak longer because that gets boring, at least for me. Hi, Julia. Julia is an image maker. Sandra is a copyright librarian, and Brenda's working with moving image and film, looking at invisible mending of cloth in factories, and that's for PhD major study. Thank you everyone for sharing. For everyone else, if you want to pop it in the chat.
Going to put mine in too.
Oh, so you don't want to say what it is?
Well, no, I will. So my name's Claire. I'm an installation artist and I focus mainly on drawing with non-traditional materials.
Perfect. And if we don't get to pick on everyone else, so today we're going to sort of talk around some of the key concepts. Of course, you can ask questions which are related. If I know a question, if I know the answer, I will answer today or we'll take it away. That seems to have worked last time as well. And we have other workshops coming along as well. So we have one with photography, we have fashion and music. And is
Trademarks.
Trademarks, yes. So if you want to sort of have a related question with that, you're welcome to, but it's meant to be a workshop. So I do have slides and I will be talking to everyone, but I don't expect that to last for 2 hours. There are not that many slides anyway. And I'll sort of try to do that with Claire to bounce off ideas to see if Claire can find her category of works when we're sort of, if there's a niche to sort of place your work in there. If not, what does that mean? And we will sort of go through the slides like Claire has already mentioned. Anyone having a question, do pop it in the chat, or if you want to just sort of unmute yourselves and start making the question known to us both. But we would like to hear from everyone. So thank you, Katrina, for saying that you're in art and fashion gallery. There we have Mac as well.
There's Mac. Hi. Oh my gosh, it's been so long. How are you?
Unmute button.
Unmute, yeah. Hi, Claire. It's nice to see you.
You
yeah,
too. Oh my gosh, it's been such a while.
Yes, indeed.
Nice to see you. You're keeping all right?
Yeah, I am. Thank you. Well,
good.
I'm back.
You're back, yes.
Yeah. So, PGR student. There you go.
And
Right, great.
what is your creative practice, Mac? What do you do?
In terms of fine art?
Well, anything really, yes. We've had a
fine
range.
art, mostly concerned with tracing and the process and the outcomes of tracing, looking at tracings as an end in themselves and trace as a theoretical concept. So that's what I'm looking at.
That's very interesting. I wish I could have a picture to go with that, but we'll work towards that. We'll work towards that. So everyone else, we do have some silent mysteries in the room. As people will know, I do tend to sort of poke people a little bit, but I'm not going to do that just now. So if everyone is sort of happy with just starting, maybe Claire, we should start with just a few initial notes. But like we said, it's meant to be an interactive workshop. You have a question, pop it in, and also maybe helping out with illustrations. It would also sort of be helpful as we move along. But let's now, fingers crossed, you know how you always try it, Michael. So you try it, it works like 5 times and then eventually it won't. Okay, so now I need to do this. And yeah, excellent. So the slide swap display is already put in motion and it's all worked. Claire, if there's anything in the chat, can you just sort of tell me? And
will do. Got
yeah. So for everyone, I think the polite thing from me is to introduce myself. You would have seen the biography also in the Eventbrite sign-on page, but my name is Metka. I'm a lecturer in law and I teach intellectual property law. I do also EU law, arbitration, mediations, alternative dispute resolution. But I am mostly in commercial areas, if you will, and intellectual property falls within that scope. What are we doing today? We're looking at some of the key concepts in copyright that have to do with artistic works. Now, if you have a question that falls outside of that, if you're keen on literary works and other types of works, please, by all means, do ask a question. But just to remind everyone, we do have a set of other workshops as well, hopefully to look into a little bit more detail as well. I was hoping to also have some of the law researchers here in the room. I haven't seen any, but they exist. So my suggestion to all the artists in the room, which is everyone but me, I guess, and well, we do have also a librarian, which I don't know whether our librarian is a librarian / artist or something else in the background. But if you want to reach out and have those kind of questions that you don't feel comfortable in talking to me about, although there's no reason why not to, you can also reach out to law students. They're also very keen on learning in practice how things happen, what are the issues, what are the questions that artists might have. So do reach out to each other. You can do it either on Twitter, I've sort of come up with a hashtag, or just connect through Claire and myself, and we can start thinking about building those networks. So once you leave the university, you have that, at least one lawyer you can call and say, hey, you remember we had those workshops together? I have this thing, can you help out? Oh, I can't, but I have a friend who does this. So try to think of those strategic ways as well. And once we're allowed to, I'm really keen on also seeing everyone's work in galleries, and you'll have degree shows and all sorts of things. So it's going to be very, very, very fun. So today we're looking at now, artistic works, we're going to look at the legal definitions here, and I'm quite keen to hear how that matches with everyone else's definition in the room, if there is one at all, or if there is a concept that you're looking at. We're also going to look at the requirement of originality. Originality is the requirement to get the legal protection in the system. We're going to look at idea expression dichotomy, because that is the legal principle that tells us that ideas are not protectable in copyright. So just because you thought of something, unless you've expressed it in the world, as vague as that concept might be, so ideas themselves are not something we can have monopolies over. And then we'll look at some of the rights, economic rights and moral rights. The reason why we've already spoken in the first workshop on ABC, so when we were just sort of mapping the area, we touched on economic rights, and that's something that people are a bit more familiar with anyway. But there are 2 points that I think I've sort of tried to flesh out for today a little bit more. One is the droit de suite, or the ARR, so the author's right to be paid royalties when further on sales happen of their work. So you have a painting, you sold it the first time, then after 5 years, it gets sold for a really smashing amount of money. Are you entitled to any royalties of that or percentage? Yes, you are. So we're just going to look at that, or just maybe put that concept in everyone's line of vision. And also moral rights. They're not that extensive in the UK, but they do exist. So I would just sort of perhaps chat to everyone about this concept of moral rights, and maybe thinking about that when you are looking at whether it's contracts or other practices. We can have a chat around that anyway to see how people are familiar with that, right, Claire? Contracts and how residencies and things like that, sometimes it's just first you need to be made aware that these concepts exist, and then maybe later on when you do read some of the documents, you say, oh, that's what they mean here when they say you're giving away everything forever and ever. Okay, now this is also the concept of copyright. I do apologize for the circus behind me, but that's the main road and the ambulance is driving past. What is copyright? So just a reminder, again, we did cover this in our first workshop, but it's one of the key set of definitions that I always just like to remind everyone when talking about copyright. Copyrights are linked to states, to countries. So they are what we call in law territorial rights. So there is no European copyright. There is no US, well, US is a country, so there is US copyright, but there is no global or world copyright. So copyright is always, the protection is always linked to a state. So for us currently, the most relevant one is the UK copyright, and that's regulated through the UK Copyright Act. And of course, it depends on where you are active that you would be interested in knowing what your rights are. So the first thing to remember is that there's no global or world copyright. The second thing is that you get a set of rights given by copyright, exclusive rights they're called, and they give the owners or proprietors, they give them some controls over what happens with work. That's what it is. An exclusive right is the right to control what happens with copies, how the copies are distributed, can you put things online, and so forth. Okay, so sometimes copyright is also referred to as a monopoly, a right to control what happens with the creative works. In the UK, as with most countries, we don't have to register copyright. Copyright happens or is created, will exist as soon as you've created the work. So I've made a painting. Once I've done that, copyright exists in that painting. I'm the author, and there is a presumption, a first rule, if you will, that I'm also the owner of copyright. Okay, so no registration required. Now, if you ever heard that in the US, there is a requirement of registration that only goes to the requirement of what you can get in front of the courts. So in the US, you will be required, or it will be recommended that you register copyright if you want the full extent of what the courts can give you, what kind of advantages from the system you can get. But in the UK, there is no requirement of registration. So if you ever were to go to court or you had a dispute, you would first have to go through a list of requirements to show that you are the copyright owner in said artistic work, whatever the work is. Okay. What is copyright? It's also considered to be an intangible property right, a property right. So often you will see it with companies or other business owners. It's put on the books. It's considered to be a valuable asset. Okay. Now that might be something that artists will say, oh, I don't care about that. We all have to make rent, or we have other expenses. So just being aware that there is a commercial side to potentially to exploitation or use of copyright related to your works is just an informed position to be in. You decide how you want to take advantage of that or not, but it's something to keep in mind. And that's why when companies are negotiating with you, so imagine you are in a position of being commissioned for something, I don't know, for graphic work for somebody to use on their packaging for their particular product, and they might be a little bit fidgety around, you know, you give me copyright and it will be forever and ever and ever. It is because if you actually assign copyright to them for under whatever the conditions of the contract are, that company will put that on the books. They'll say, right, we have copyright now in that design, in that picture that they're putting on packaging, and they will count that towards assets. So even if you're not interested in the monetary side of intellectual property rights or copyright, perhaps your partners that you're dealing with might have that in mind, and it might be an important negotiation point for them as well. Okay. And also copyright is not only what it gives to you, it's also important to keep that in mind as a limitation or a boundary when you're trying to use other people's works. So if you're trying to take parts of other people's work, you should be aware of how much you can take and when you're taking too much. And in general, we would say, again, if you're just being inspired by other people's work, you're not imitating, you're just being inspired, i.e. you're sharing the idea, not the expression of the idea, you're fine. Or even if you are copying substantial parts of the work, you have a defense available, fair dealing defenses, such as, again, things that we covered in the last session, and we'll cover in other sessions as well, but things like fair dealing for reporting current events, or if you're creating parodies, pastiche, caricature, or quotation and other parts. So this is just an overview where I just wanted to sort of touch base on some of the key concepts, but we're going to come back to those, I suspect, anyway. Okay, so artistic works is what we're focusing on today. And perhaps, so let's just sort of state where it is, and I'll stop and start asking maybe Claire to see if she can find her category once I come to the statutory definition. So copyright protects. Copyright is a legal right given by the UK, by the country, by the state. How do we know what the rules are? We have to look at the Copyright Act. Sometimes I will refer to certain provisions, but just ignore them, yeah? It's not meant to be the kind of work where we're studying law together. So there are 8 categories of works that are protected under the Copyright Act. And that is a specifically or a unique approach that the UK has taken that we don't see in different systems. So your work has to fit in one of the 8 categories if you want to get protection. What are these categories? They are the first LDMA, so the ones that will get the most protection: literary, dramatic, musical, or artistic works. And today we're focusing on artistic works. And these are given the most protection only when they're considered to also be original. And we'll come to that standard. What is originality? I don't suspect anyone will have troubles with that, but you'll see what I mean by originality, what the courts have said as originality. It's the standard of author's own intellectual creation. Why do we say that this has the broadest scope of protection? Why do you get the most? It's the best to have this type of copyright. It's because it protects against taking or making exact copies. So it protects your work. And also it protects you or gives you control over copies that are indirect copies, so substantially similar copies. So not just identical versions of your work, but also substantially similar types of works, which it sounds good in principle, a bit more difficult to determine in practice. Now you then have a separate category of works: films, sound recordings, broadcasts, and typographical arrangements of published editions. The last one is what a page looks like in a book. You know how a publisher sets up the book, the page, what it looks like. That's a separate copyright that goes to the publisher, and that is a bit shorter. It's only 25 years after publication. Those types of works are rewarded or given protection because of their investment. If you think about sound recordings, it's where record labels are making their money and so forth. These are they have less protection because only the works themselves are protected. So sound recordings themselves, not similar sound recordings, and there is no requirement of originality. There are additional requirements as well. So if you have literally music and dramatic works, you have to write it down, note it, fix it in a medium. So if I just speak a particular poem and it sort of disappears in the air, it won't attract copyright unless I've written it down, or at least maybe made a recording on voice. This does not exist for artistic works. So there's no, in the law, there's no requirement of a fixation for artistic works. But in practice, there were some difficulties around how the courts have interpreted, how narrowly they've interpreted what a painting is, for example. So it's a little bit of a hit and miss there. It's open to interpretation whether or not artistic works need to be fixed or not. And there's also a requirement of qualification. So there has to be a link with the UK. Either you, as the creator, are a resident or a citizen, or the work was first published here in the UK. Okay, so here is where I take a little bit of a break, and you see in front of you artistic works, and it says in this part, so this is the act, this is what the statute says. Artistic work means, and then you have a list: graphic work, photograph, sculpture, or collage, irrespective of artistic quality. Then you have a work of architecture being a building or a model for a building, or a work of artistic craftsmanship. You further have definition of building, graphic work, and graphic work, which is from the first, so 1A, has then a further definition or includes painting, drawing, diagram, so forth, so forth, so forth. Claire, where does your work fit in?
So I think mine would be, God, let me read it.
Yeah, take your time. I mean, we have so much time now, so. And that's for everyone, you know, try to find your, I mean, we've had a photographer, so there's no questions there. Although when we have a separate workshop, I've spoken to a photographer who's actually said that some of her peers don't think that what she does is photograph because she mixes mediums.
Yeah.
So even the definition of a photograph, you know, it's a bit more clear cut when I talk to my law students. Photograph, there's only one single way of viewing it.
Yeah.
Not the same when I speak to some of the artists. So would be interesting to have everyone pitch in. Have you found your category?
I think that's kind of where I'm getting a little bit unstuck, because it's not really a collage, but it might be.
Yeah.
Some people might not think it's a drawing, but I do. I think it's a little bit confusing, actually.
So I think the only risk you would have under the law is if you can't even say that it's a combination of the two. So one of the problems, for example, one of the cases we've had in the past is Oasis, so the band. I don't know if everyone sort of remembers Oasis. I don't know if they're still around. So they had a photo shoot scene happening, and what they did was they had a pool. There was a car immersed in the pool and band members around. So it was like a scene, right? A set scene. Now then there was a journalist hiding in the bushes, took a snapshot of that photo shoot scene and published it in the newspaper. Now, of course, from that perspective, he didn't take the photograph itself, which was the cover for the album. Yeah? So he didn't take that photograph. So copyright wasn't infringed in the photograph. What he's done is he's actually just taken the picture of the photo shoot scene itself. And in that case, the court said, well, look, the photo shoot scene is static, so it's not dramatic work. There's no action. It's not a collage because it wasn't stuck. You know, the car is placed in the pool and all of that. So it had a very rigid approach to protecting that photo shoot scene. I'm not saying that that's necessarily sort of something that would be a problem for anyone's work here. And, you know, maybe now with a few decades on to the courts also being influenced by the European sources, it might not be as problematic. But yes, if you look at the sort of the, you know, this is almost like an entire menu of artistic works. This is it. I like the faces. Mag, do you want to share a little bit? You know, I aim to learn also from the artist in the room. So what do we think of this menu of artistic works?
Well, it really, it's a sort of classic list of what you might think art might consist of. But I can certainly think of a lot of things that wouldn't necessarily fit into that. I mean, for instance, photography, a recording of light or other radiation on any medium. What about images, digital images that are never actually recorded on a medium, unless you actually consider a computer screen a medium?
Mm-hmm.
It might just exist digitally and nothing else. Because they don't exist at all in reality. They're just virtual images. So there's that thing to have. I mean, if Claire's doing similar things to the things I remember her doing on her MA and her residency, then, you know, you couldn't describe them as paintings or drawings. You could stick them loosely under the heading of diagram of some sort.
Yeah, maybe. Yeah.
But, that's it.
Yeah.
But I'm also thinking about some of the contemporary works in post-conceptualism, which are described as copying without copying. And the artist's intervention, when you look at it, do you remember the Marlborough Cowboy, Claire?
Yeah,
I've forgotten the artist. It was exactly the same as the Marlborough advert. But the artist's intervention was to use it for artistic purposes. But visually, it's identical. Philosophically, there is an artist's intervention in the process of copying it. So it's described as copying without copying. I don't recall any copyright process against the artist that did that by the Marlborough Company. But maybe there was. I don't know.
Was that artist here or in the US?
That would be the US.
Because in the US, they have a little bit more leeway in the sense of fair use. So the defenses they have there is fair use defense. So as long as the use by the artist had a transformative meaning, and here this is the artistic intervention, so it depends on how extensive the intervention was, they might escape copyright infringement. Here in the UK, it would be trickier, i.e. there would be copyright infringement if anyone bothered to do something about it. Yeah.
I did ask a question, which is perhaps it's not the right time to
Anytime, yeah.
In, but when we're writing our dissertations, we quote authors all the time and we reference the quote properly and everything. What about using a picture from the book? Is it the same process as long as you put the reference and where it was from in the book and so on?
Definitely for dissertation purposes, you're clear. So as long as you sort of follow the best practices of referencing, you're covered by both. So in this case, if you're doing quotation and you're just taking a snippet from a book, or if you're using a photograph and you attribute where you got it, for dissertation purposes, there is an exception. So fair dealing for private study and research. So dissertation purposes, it would be fine. I just would not.
Sorry to digress.
No. As Claire knows, I always welcome that because it's much more fun for me.
Yeah. Hi, Rachel. Nice to see you.
Hi, Rachel. Yes, Rachel. Where is your work, Rachel? Where would you fit it?
Mine's it's easy. It's painting, but I have worked with other media in the past that wouldn't be part of this list. But it's a list that seems like it's from like the 19th century, like French Academy. So it doesn't feel very representative of contemporary art practice, I'd probably say.
So are there obvious categories you would all add to the list?
Yeah, installation, performance, digital media. I mean, you could just go on. Collaboration, intervention, like Max said. Yeah, it could be extended, definitely.
Yeah.
I mean, with
Metka, you probably wouldn't be aware that like say a collaboration of an artist's collective selling food in in a park, which as an artwork, or an artist parking a caravan in various places around a city, towing a block of ice around a city till it melts. These kind of things don't come under any of these categories.
I guess that would be maybe performance,
Dramatic.
wouldn't
That
it?
would be under dramatic works. So there's a separate category, something that traditionally lawyers at least think, in terms of a film or a little cartoon or, plays on a theater stage, the dramatic work. So I'm thinking that works where an artist is sort of dragging a cube of ice, until it goes away, that I think would qualify under the terms of a dramatic work. So, and that would be, just like Rachel, you said, performances, I think they might be, so artistic performance would probably fit, not with artistic works, here it doesn't have room, but because it's a dynamic piece of work, it would fall under dramatic works.
Yeah, so I suppose installations.
No, installations are missing. So installations are not there, because installations, if I understand correctly, they're fixed, right? There's no, or there could be motion.
Not necessarily. Not necessarily. Invite a pile of sweets in the studio and you're invited to help yourself.
Yeah, it's
yeah.
It's got many meanings, hasn't it? Yeah, I mean, there's the thing of site specific as well, isn't there? Which a lot of my work is. Yeah, I struggle with this selection of descriptives here, I think.
I mean, the good thing is, at least when it comes to graphic works, you do see it says graphic work includes.
Yeah.
Which does allow for some, but
Yeah.
Of course, would need expert evidence then to sort of help them a little bit, but you couldn't just add. So installation as a completely new category could not be added, because the courts have actually, and I'll give you 2 examples, have been quite rigid in the past when new sort of things were starting to pop up. Maybe then when people or the society sort of gets more used to certain things, even the courts might catch up, but it's not the best. Let's say that they're not at the forefront of imaginative thought in terms of, oh yes, of course, installations missing in the act. So,
well, for an example, I was in court once listening to this case, and the judge actually asked what a Twix bar was. So,
is that a sign of a very healthy diet by the judge? Like,
Okay, so we've got a question coming on the chat from Julia. She says, my work is mainly and heavily collage, so I tend to use a lot of different images. I struggle often knowing whenever I can use something or not.
Yeah, so we've had those discussions in the last session when it comes to what is infringing. So when you're using other people's work, if you're taking substantial parts, and again, this is a fact-specific question and query, what is a substantial part of that work where you're borrowing from, then you might be infringing, unless you have one of the defenses available. And the defenses available are the ones under fair dealing. So parody, pastiche, not collage, parody, pastiche, caricature, reporting current events, quotation, private study and research, and those really are the ones that sort of exist. So just taking from other people's work, you could get in trouble if you don't have permission to do that. And that is the difference, exactly as we were speaking before, this transformative use defense, the fair use defense that exists in the US, even though recently there have been some changes even there, and they found some copyright infringement in cases where prior we thought that the artists would have the freedom to explore different mediums. But in the UK, we have fair dealing defense, and it's much more limited and it's much more protective of copyright owners. So unless you have one of the defenses, so if you're doing parody, you're most likely covered as long as that parody is fair. And again, there's a little bit of a further assessment on what that means. But basically that's the assessment. Have you taken something from other people's work which amounts to substantial part of their work? It doesn't mean how important it is to you. It's important what you've taken from other people's work. Yeah.
Okay.
I know it's sort of just a basic answer. There's no formula. There's no clear cut, 1 + 1 equals. It's the law. It's all open to interpretation, but that's the formula. You have to be careful of substantial. The other option is that when you are drawing, if that works artistically, if you can just go to a data bank of images that you can freely use and build on. So things that we've explored together were the Creative Commons database, where you can just go online, search, see what's on the database for Creative Commons. You have different options. One is that you just sort of freely use, and it allows you to use the images put there under those terms. And then you have additional ones. One is where the license itself allows you to do whatever you want with the original work. So you can build, reshape, paint over, whatever you want creatively. And there's even a further on category that you can use those images for commercial use. So there are even images on the Creative Commons database that will allow you to do that. So if you wanted to, you take the picture and put it in your book and start selling the books. So there are different types of Creative Commons licenses. If you know which one you need, you just go into the database and find something, and you'll be covered then. You just use the license. You need to remember the terms. If that's of interest, we can show that again, but it's what we covered with Claire in the first group. We've covered that with the Creative
I'll put the link actually to the talk, the recording of that talk in the chat, which might be useful.
Yeah.
We've just got a question in from Helen. She says she has a similar question to Julia. When using a composition for photography, I might, for example, want to photograph ornate decorated skulls. Is this a problem? The photograph and composition is mine, but the decorated skull would be someone else's work.
So if that would qualify, which, I will have in a few moments, I will have a definition of, again, it depends. So I'm guessing that the decorated skull would fall within one of these categories, right? Not sure whether it's a sculpture or, can you help me out? Where would that fall under?
An ornament.
Ornament. Yeah, I don't see a no. So let's say it would be, I think it would be a sculpture under the test. I'm going to show that the Stormtrooper helmet failed. But if you're just taking pictures of artistically protected work, copyright protected works, you have to have permission. If you don't, you are infringing.
Okay. Helen's just said it's a mass-produced ornament.
Again, it depends on whether it's in copyright protection in here. So, and it might be, so the other difficulty you might have with utility products, or if you're taking pictures, is when you will have a design right, so a separate right. Designs are intellectual property rights that protect the appearance of products. Design rights, the ones that we're most sort of familiar with, are cars or luxury fashion items, things like that. So it depends. You might have a design right that could clash. Now, that might not happen. That might not be problematic in most cases when artists do create. But if you become hugely successful and there's a commercial success attached to that, or if the brand owner or the design owner does not like your message, they might actually sort of take an issue with that. And with photographs, it's different. If you're taking pictures of, things that are out there in the world, you can do, right? So if you take a picture of a building, you can do. It's in the public domain. Yeah, I see there's 17 more, but I'm sort of guessing we're good to continue a little bit. Or Claire, is there another? Yeah.
No, we're good. You can continue on to the next part.
Yeah. So a very interesting sort of, Rachel has it very clear. So Rachel, what is a painting?
I honestly cannot answer this. I think, you have expanded painting now, and so my definitions are out the window, I'm afraid. So.
You will just see that, lawyers need to work from the category. So, we're uncomfortable with too many loose borders, I guess, around concepts, at least when it comes to sort of deciding certain cases. And one of the cases, so this is usually, what is a painting was not that difficult for courts to determine. They could see it. They would say, yeah, painting. So it's one of the obvious ones, right? Just like Rachel, you said. So you were not wrong there. But we did have some of the, things happen in life. And there are certain parties that try to actually say that something is a painting, even though traditionally it wasn't seen as a painting beforehand. So this was one of the cases where facial makeup was pitched or argued as a painting. So the court there said a painting is not an idea, it's an object, and paint without a surface is not a painting. So that's why they refuse to consider this setup as a painting, right? Now, of course, this was the case was, many, many decades ago. So it was in 1983. Would the same still hold true over tattoos or other kind of body art where you might want to argue that that is a graphic work, right? I mean, you will have protection over, usually, I'm sort of guessing a little bit. I'm not a tattoo expert, but you do have sort of the drawings on them will be on some kind of paper surface before they're sort of transferred to skin, right? And that would not be problematic to protect that. But, it's a permanent sort of, once you have that tattoo on skin, it's permanent. It's just as any other kind of surface. So that view was very, very narrow back in 1983. And, the interest of the artist was to get this as copyright protected, because copyright protection is how long is for the duration of your life as the author plus 70 years after your death, right? So it's a very long period. And compared to some of the other intellectual property rights, that is the benefit of copyright, that it's a very long term of protection. Now, so we've done the painting. So can we do the sculpture one now? And keeping in mind the ornate skull type thing. So what is a sculpture? People can write in the chat, or we can have a chat sort of with each other. Is that clearly defined to all of our lecturers in the room? I'm looking at Rachel and Claire just because I see you both, but I would be gladly picking on everyone else, but I don't see everyone else. So do we know what a sculpture is?
I guess it's something that's 3D rather than 2D.
I suppose artists are constantly, I think, Metka, you pointed this out, are constantly trying to push the boundaries of their medium in lots of expanded ways. So it's what Rosalind Krauss would call the post-medium condition. So I think artists, always trying to sort of move away from traditional definitions, which is not helpful probably for law.
No.
But it's not the artists that actually run into difficulties when it comes to sculpture. It's companies trying to get protection in things that have nothing to do with, art, really. So, what is a sculpture? You would think we would all agree. We see it and we say, yeah, that's a sculpture. It's something that, we would expect to admire and so forth and so forth. But it was something that even now is a really good thing to sort of think about when you're trying to test students, or when you're trying to think about what would be the type of protection given in different 3D objects. So just like Claire, you were starting with, it's a 3D object as opposed to 2D, but where do we draw the line? First, the act says, so the law says sculpture includes a cast or model made for purposes of sculpture. So not very helpful, is it? Now, where the definition of a sculpture was tested is with stormtrooper helmets. Yeah, so is this, so the helmet itself, I have a picture of the entire thing. Is the helmet itself a sculpture? That was the question in front of the court, because somebody came along and the design rights already expired. Somebody came along and started to make the molds and the helmets themselves. And the owner of, so Lucasfilm was not happy. So the owner of the IP rights, or, of the entire Star Wars franchise was not happy that somebody else would come along and say, right, I'm going to make a helmet and sell them off cheaper. They're going to look the same. And fans will want to, buy them from me rather than from the more expensive Lucasfilm. And of course, if the company was to claim the longest term of protection, which is the duration of the life of the author plus 70 years after their death, they needed to convince the court that the helmet itself of the entire outfit there is a sculpture. So what do we think? Is it a sculpture?
Well, it's also fashion as well, isn't it? I guess. Kind of. Not that I would wear it, but it's clothing of sorts, isn't it? So I guess it kind of tips over into fashion and design. Yeah.
Isn't there an aspect of intent as well? The author's intent associated with an object when you're talking about defining it. So the author's intent when they made the helmet was, I would guess, nothing to do with sculpture. It's more to do with design. So I suppose you could build an argument that no, it's not a sculpture. Yeah.
I always do that, so I put it in. There we go. Claire, you're a fan, so what do you think?
Yes, I am.
Usually you see a little bit more passion in how important this. So is this helmet the same as any other helmet you see, soldiers wearing in a war movie, whether it's Second World War or an Iraqi war or whichever? Is it the same, the helmet itself? In terms of the function it does for the film and everything.
Well, it's like Julie's just Denise has just put in the comments. It's a costume, isn't it? I suppose. For a film, it's a costume.
And there is also the matter of use as well as intent. I mean, for instance, Marcel Duchamp takes a urinal and displays that as a work of art.
Yeah.
The maker's intent was anything but artistic when that was made, but the artist Marcel Duchamp, the use that he put it to was sculptural. So if you displayed the stormtrooper's helmet as a piece of artwork, you could claim it was a sculpture. But unless you had a prehistory of that, when you're trying to claim it was a sculpture, I think you'd probably find it hard to build a case that it was a sculpture. It has sculptural elements, but then so does every object that's ever been made.
Yeah. Maybe with that, let's see what the court said would be the right test, right? So first, the court said, so one of the courts, the middle court said, well, let's have an elephant test. I know it when I see it. So I'll see something, I'll say, yeah, it's a sculpture, or no, it's not a sculpture, right? But the other court, so the top and the bottom, said, no, we need a little bit more around questions to be asked in order to come to a sensible conclusion. And it speaks to a few points that we were discussing now. So first, we would just think about what is the normal understanding, the meaning we would all, and that's what we were chatting about now, sort of what would we understand under sculpture. And then the court also said it goes beyond just what you see in a gallery. So it could be other aspects, things we see, 3D installations we see in the world. And so it doesn't have to be just something you see in a gallery. So it's not as narrow as that. What is normally considered as a sculpture, so not just the meaning of the word, but our perceptions, what the society value as a sculpture. And I think here, artists trying to push those boundaries, things like, putting a toilet somewhere, or a banana, taking a banana, putting it on a wall somewhere, and then having artists sort of going at it and, eating the bananas, so performance art and all sorts of things. So that opens everyone's minds, and it sort of also challenges around, what are normal understandings around particular pieces of art. No judgment is to be made about artistic work. So worth is something good or not, and that was going in favor of the stormtrooper helmet there. And not everything that's 3D is a sculpture. So that's, I think we would all agree, something that needed to be said, but it's hardly something we would not be agreeing on. And then we have those two where it goes to the artist's hand, right? What was the purpose behind creating this? So visual appeal should be part of the sculpture's purpose. So what it looks like. It's not just by accident. And even if it does have, so things like, you might have a traffic sign or something, but it might also have a different aim, that it should be enjoyed by the public when they walk past. So something might be functional, but if it was created with the intent to be enjoyed as a visual thing, it might still fall within the definition of sculpture, even though it might have a function in normal life. Right? So these were the questions. So what do we think of the questions that the court came up with? You're the artists in the room. Does it work?
I think number 7, really, it must be intended to be enjoyed as a visual thing. Yeah, okay. That's design, it's fashion, it's even hairstyles. Yeah,
very broad, yeah.
It's very, very broad. It's very open, and I'm very careful to avoid the use of the word art in here, associated with the word sculpture, because there is no definition of that. Okay, if you employ item 7, so it wasn't designed to be enjoyed as a visual thing. Well, of course it was. Yeah.
It was created. So the court said that when you're looking at that military helmet, yes, it was part of. It was different. It was stormtrooper helmet because it was an imaginary world, right? Star Wars doesn't happen in Wolverhampton, School of Arts, and it's all of us running around the building. So the court said that was just the artistic work was actually the film, and this had a function to play in the film itself. Now, people have had sort of impressions and opinions divided on this, and usually it's sort of more to do with whether they're a Star Wars fan, or at least they appreciate everything that goes into that, or they just see it as another movie. So, making it more like, it's just another military helmet. It's no different to that. It's a functional object. Get on with it. Yeah. But it's the test. So this is how courts will approach different artworks when they have difference in opinion. One side said this is not a sculpture. The other one said it is a sculpture. And the entire case turned on this question. There you go. I'm not going to comment, but this is something that is just sort of very entertaining to look at when you're trying to discuss these points. Do we all know what is a sculpture? We think we do until we come to a question, okay, how we define that, right? You do have also protection of, so under copyright, you'll have protection of works of artistic craftsmanship, and that can sort of be sometimes of interest to some of the artists that are doing perhaps artistic craftsmanship, not just artworks. Here you have a different kind of standard for protection. So artistic craftsmanship will be protected if it has an artistic appeal, a visual appeal. So in one of the older cases where this was sort of looked at was a set of 2 chairs and a settee, and whether or not that's sort of copyright protected. Now, I am from a civil law background. When I hear copyright protecting things like, a sofa, just doesn't make sense to me, but it's part of the UK copyright system. And the requirement is that it has to have an artistic appeal, this functional object, so work of artistic craftsmanship. If it does, it will get copyright protection under the umbrella of artistic work. It doesn't mean that they are the same. There is this additional requirement, but courts have said, so, if this particular work is genuinely admired by the public because it values a thing for its appearance, and the public will get pleasure or satisfaction, whether emotional or intellectual, from looking at it, then, it will get this protection. And that's sort of, but the court were also very clear that this is not the same as artwork. So the standard to look at that. And I know we do have some of our students also working different kind of craftsmanships and works that potentially could fall under this. When it does come to fashion that we've mentioned, we'll have a separate workshop for that. But for fashion, we would say that the best route for protection there is design rights. That's the most obvious of categories for intellectual property. I'm not saying that copyright is not available, but the design right system is much more tailored to protecting the appearance of products as such. Okay, originality. So again, going back to the room, what do we think is originality when it comes to works? What would you say when you see something and you're thinking, oh, is that derivative? I think that's the term that's sort of used, right? Oh, that's purely derivative. Oh, this is original. What would you say is sort of the test, or how would you sort of describe something that's, I don't want to use terms. So is it newness? Is it uniqueness? Is it imagination? What is originality? Okay, Denise is saying unique, yeah. Because this is the legal standard to get protection. So your artwork needs to be original to get copyright protection.
I guess all artworks exist in their time, which means that they are part of a flow of artworks through time. Everyone's work has elements of previous things that you've seen. It's influenced by things. It's influenced by other artworks. It's influenced by society. It's influenced by where you are. But I guess when those elements are put together into an artwork, which, although it draws on previous artworks and experience, that it's a new formulation as such. Originality is something that post-conceptual artists are very keen to try and discredit in some way, that there's no such thing as originality. But it can be new without necessarily being original. I think that's what I'm trying to say.
Mm-hmm. Claire, you've said personal style within the work, yeah? So linked to the author themselves, absolutely.
Yeah.
And I agree with everyone's observations, and the requirement for intellectual property to be given, linking it to novelty or newness, doesn't exist in copyright. So that's not the standard. That's for patents, technical solutions to technical problems. Originality in copyright, I'm just clicking through my different screens here. Originality goes to author's own intellectual creation. So it originates with the author. It's their product of the mind as expressed in real world. And it goes to the creative choices. So everyone's saying it's personal, it's from the author. You're all absolutely bang on. And this is different. This is the European influence. Traditionally, the UK protection or originality standard was linked to skill, labor, and judgment, which for me, again, because I'm a civil law lawyer from so continental Europe educated, for me that was a way too low of a threshold, because under skill, labor, and judgment, when you have a label of a tomato soup can, you have a label of instructions, it falls under originality standard. It's skill, labor, and judgment. The recipe written on that can of soup. This is a different kind of standard. It goes to creative choices. So this is just one of the a quote from one of the courts. So it goes to choice, sequence, and combination. So here in this context, it was literary work. So it was words in the way that the author may express their creativity in an original manner and achieve a result, which is an intellectual creation. So the standard is not, it has to be new, never happened before. Because it's exactly as Mac was saying, there's standing on the shoulder of giants, all having references with the past, we're all embedded in our cultures and societies. It's impossible for artwork to be completely new. Okay, perfect. So that's the standard of originality. And the other concept I wanted to just briefly, and it goes to some of the questions we already had, right? What can I take? What can I borrow, right? Idea expression is something that in copyright law is where we draw the line. So idea expression is not only the standard for what we protect expressions of ideas, not ideas themselves. It's also the line we draw between what you can borrow and what you cannot take without permission. So the line between inspiration and imitation. Idea expression is, so some of the courts have said, when you're looking at two works, and they're not exact copies, but they might be indirect copies, what you cannot permit is for one of the parties to take the substantial part of the other work or the expression from the other work without permission, okay? What is this idea expression dichotomy? Sometimes it's difficult to pinpoint, but if you look at the picture of the sunflower, right, the idea of a flower, the idea of sunflower, the way in which you want to express that, even in graphic works, will vary substantially, right? It's all about how you execute the idea, right? I often sort of have a running joke with my students, you know, this idea expression dichotomy. I will tell them, I'm going to write a book, I'm going to write a novel about all my students in Wolverhampton from this year. And my storyline will be that they were all the best students ever, but they were into magic, and that's why they all failed the course. Whatever, I sort of make something up. And I say, that's my idea. I'm going to be writing about law students in Wolverhampton 2020, 2021. If somebody else comes along and writes a story about students at the law school from this year, it doesn't mean they're infringing my idea. If, however, if you then think about, because obviously they cannot link it to my stories, I haven't written anything, but if you think about, you know, well-known novels or well-known stories, thinking about Harry Potter, and where would you draw the line between idea of a young boy who has friends and does magic and runs around in a particular school, where that's just the idea of young kids having magic, and then somebody else writing a story where there's this academy and there's this, you know, wizard that's threatening the existence of everyone, potentially leaving a scar somewhere. It might be taking too much, it might be taking the expression, not just the idea. And I think, having had some conversations, it might be something you need to train yourself in through, I'm not saying necessarily through university, but just expressing yourself. So first you might be imitating to sort of think about technique and sort of building that particular expression. But then with time, you probably do get a feel over what is your own expression and what is you taking stuff from others. It's almost like you develop your own print. Or if that doesn't work, think about it this way. If somebody else were to come along and take your work in the way that you're taking their work, would you be happy with it? Would you object? Or would you have actually wanted them to ask you for permission to do that? I mean, I don't know, is that something that sort of, when you're thinking about other people's work, is that something that, you know, if two expressions or two types of paintings are very similar, I know there's a lot of talk around people belonging to the same school. Is that sort of still something that happens even today, or is that sort of something that happened more in the past? That they were from different time periods and they sort of had the same characteristics and so forth. Does that still happen today?
Do you mean the same style from a certain school?
Yeah.
I think it does still happen, actually. Yeah. Not in this university.
In other places.
But I've heard that it does. So a graduate from a certain university, you could probably tell where they come from because of their style of work. And I do think you still get that with some unis today. Max nodded. But we're definitely not one of those. Yeah, but yeah, it does still happen.
Do you all see it as a style, or do you actually get confused as to who sort of, or is it the same thing that it all becomes so not generic, but standardized in a way that?
Well, it's to do with the teaching, isn't it? I guess. I guess it's standardized. I don't know.
I think I have a small book downstairs somewhere which is called Steal Like an Artist, and I think what you tend to find is that if someone in your group comes up with an idea, you start finding it repeating in other people's artworks if they think it's a good idea. I think I remember Antoinette telling me that she started introducing a lot of pink into her paintings, and then all of a sudden everybody else's paintings were pink as well. Yeah, that happens. But you're not infringing any copyright when you do that. No. I do recall reading about the studios that Picasso had in Paris. It's called La Bateau, I think. And he used to go around looking at other artists' work in their studios. And in the end, they started locking their doors because they started seeing all the elements of their work appearing in Picasso's work. You know, that's fair game amongst artists. It's not infringing any copyrights.
Well, it depends.
Or is it?
Well, it depends. It always depends on that specific set of borrowings, and drawing the line between inspiration and imitation. It would always depend on how much was taken and what is this shared idea. You know, introducing pink into a painting, there's probably ways of doing that, right? Is it just the color that's now being introduced, and it's a point? And maybe, yes, there's sort of a time period where certain things look more the same than compared to some of the others. But there's no easy answer. There's no, in general, yes, ideas are free for everyone to sort of draw on, and it's part of our common shared background and sort of pool of resources to share. But what specifically would happen in each individual case depends on the facts of those individual case. So what was taken, what was nicked. But in practice, will it always result in something? Can't imagine, you know, artists going after Picasso after he's already had his name and say, oh, I'm going to sue you for copyright infringement. You know, would that even happen? But then it becomes a question of practically sort of enforcing your rights. And I think there are some difficulties around that when it comes to online medium, online sources, people coming up with a certain thing that is very fresh, very appealing. Somebody else well-known comes along and says, I quite like that, and maybe doing it in very similar terms, but then the original artist sort of, you know, just sort of gets forgotten in the background, or even accused of them having sort of picked it in the first place. So it's not. So again, there's no easy. The answer is that it depends on whether it was just inspiration or what was taken was actually the expression of the idea itself.
Yeah, because I think like Joanne's just put a comment in about being influenced. I mean, you do get that a lot, don't you, when you're studying? Like Max just said, you know, everybody starts using pink because one person starts using it. You know, and of course there's a lot of that goes on, but it's where the line is sort of drawn, isn't it?
And, you know, that's why it's so helpful to have the fair dealing of private study and research. You can do whatever you want, you know, and when you're trying to figure it out, you can do whatever. Nobody can tell you, oh, you shouldn't be exploring that because, you know, copyright infringement. Private study and research, you know, as long as you're not printing it in books, this is what I've learned, you know, you're covered by that. But yes, I think it's the one area where you can't have a very clear answer. And that's why it's very, it has sometimes very harmful effects. The fact that the law is open, because it then comes down to how long you've been around and how comfortable you are with knowing the rules, or maybe having legal representation. that will then determine whether or not you go forward with certain piece of work or not. Because if somebody says, oh, you better stop doing that, copyright infringement, if you're not really clear on the rules around parody, because they're not clear, not because you don't know, but we don't have a clear set. Yeah, parody done like this, you've taken 25%, parody like this, you're safe. Nobody will ever tell you that. So it becomes then much more difficult to sort of be free and just go forward and say, yeah, I'm going to take the risk.
I mean, it's funny because with the example of the sunflower, I'm currently working on a project with Rachel actually as well, a Bilson art project, and part of what I'm doing is about a building, and your last session on this, Metka, has been just in my mind the whole time, like, be really careful, make it really not the same. I mean, it really isn't the same, but it's sort of, it's made me realise, I think, about sort of taking other imagery and how much you change that. I hadn't really thought about it before until your last session.
But, it's also thinking about, even if things have been protected in the past, copyright is limited in time. So you do have, yes, copyright artistic works are protected for life plus 70, but once that has expired, it's in the public domain. So that's why we can do with Mona Lisa and others whatever we want, right? Because copyright is not forever. So all artistic works, once they're in the public domain, you can draw on them. Or equivalently, if you go to Creative Commons database of imagery, you can find, how have the authors of those images given permission to the world for future use, and if you can work with those mediums. So I think, it would be really bad if sort of the rules would really limit artistic expression. It's more about just becoming aware of what you can and cannot do. But yeah. Let's just move on then to some of the rights that exist in when given to. So when you have artistic works are original, and you have those other requirements also. So there has to be a link with the UK and so forth. So I just have a question from James. I don't think Warhol had any kind of permission for anything. But again, that's a US example, transformative use. He was safe. He would not be safe here in this country. Fair. That sounded very dire, but I just wanted to sort of really make the point that we do have exceptions here in this country as well. So if some of the work that Warhol did would fall within the remit of a parody, for example, which in certain cases it could, then fine, but there's no such defense or exception as found in the US. So as long as the work is transformative, it has a new creative and expressive meaning, you're fine. So this kind of exception does not exist in the UK. So, but I don't think he had permission in those cases when he was creating. Well, I see the experts are saying no, so we all agree on that. Okay, so what are the economic rights? We've touched on that a little bit the last time. So first, with the best type of protection for your works is copyright, and copyright in its strictest meaning economic rights. The economic rights as listed in the Act are reproduction, distribution, rental and lending, performance in public, communication to the public, adaptation, but the ones I've listed do not all extend for artistic works. So for example, performance in public and the right of adaptation are not extended to artistic works. So if you look at what you get in terms of the right to control or exclusive right in artistic works, you get the following rights, right? So you get the right of reproduction, so making copies. And with artistic works, the only thing worth remembering is that that includes the conversion, so from 3D to 2D. So if I were to take a picture of a sculpture, it doesn't mean, ooh, something new. it's still a copy of the sculpture, right? So the right of reproduction is engaged. So the right of making copies is also where the intellectual property right itself gets the name, copyright, right to make copies. So that's one of the first starting rights that you get as an artist protected by copyright. You then also have, of course, the right of distribution that's also covered with artistic works. So the right of putting those copies, once they're made, into circulation. Doesn't mean just selling. If you put up for selling, that's also covered by the right of distribution. Now, of course, if you have specific works, there is a principle of exhaustion. So in that specific copy, it would not, unless we had artistic work. So maybe if you have a photograph and you're using that for commercial purposes, i.e. on postcards, things like that. But with literary books, for example, with literary works, for example, so if you have a Harry Potter novel, once the copy of that is sold, people can do whatever they want with the physical copy of the book itself, right? So there is a limit to what you can control in those specific items that people have bought. So the right of reproduction and distribution, and then also rental and lending right. I'm not sure that really applies to artistic works. It's covered, so the law gives you that right. But I don't know if that would be covered. Is there a practice of maybe lending to galleries? Is there something like that with works, with artworks? Would that be something that's done?
Maybe, yeah, maybe, but when buyers, yeah, I guess people that buy artworks, they sometimes loan them out, don't they, to galleries? I'm not really sure how that works.
Yeah.
Whether, yeah.
I don't know, because I can't see it how you would lend somebody's work without their permission anyway. I mean, then it's just nicking right from there. So, because this is usually where you see the rental or lending, you know, when we used to back in the day, when we had either VCRs, right? You would have a VHS tape and you would go to the video store and you would rent out a movie. So that was one of the big ones. Or I guess also, you know, when you have libraries, lending, so you would take out copies of books. So that's, but right now the rental and lending right does not carry that much weight anymore. The more important one is, and it's including, so it's covered or extended to artistic works as well, is communication to the public, specifically making available, so that us putting stuff online. So there's an exclusive right, the right to control what is put up online, right? So just because you've, I don't know, you've given your painting to an art gallery and they're showing it, performance in public, and that's not a specific right. So they can do that even if they don't ask you for permission, if they bought it. But what they can't do is take a picture of that and put it on their blog without your permission. So communication to the public, putting stuff online is a separate right. And it covers also artistic works, which I think is important to remember with things like Instagram and others, right? I'm not saying that practically you could go after people who are doing that, but we've had, in the first talk, we also had a little bit of a discussion around platforms having their own rules around intellectual property, Instagram, Twitter, and others. So it's important to be aware of those as well. Okay, so performance in public and the right of adaptation are not covered or extended to artistic works. What is the right of adaptation? Thinking about music or literary works. For literary works, if you're doing translation, that's the right of adaptation that's engaged, for example. Performance in public will cover also literary, music, and dramatic works. So if you want to put a play on you know, you want to show a play in a theater, that's actually putting performance in public for that particular play, which is a literary work. Or if you want to play music in a theater or in the street, for example, that's performance in public. That does not exist, that kind of right does not exist for artistic works.
Okay, now I had something like this recently where I edit a magazine and one of the contributors sent an article with some photographs. Mm-hmm. And the photographs, he said that they could not find, he thought the photographs belonged to some descendant of the people being photographed, but he couldn't find them couldn't find out anything about them, so he couldn't actually say reproduced with the permission of so-and-so. But the photographs themselves were taken in the 1930s. So they were over 70 years old. So what was there anything tricky about reproducing those photographs, which we did anyway? Yeah.
And there was no issue because probably whoever took the photographs, you don't know who that is. So two issues. One is that if those photographs, for example, were taken by somebody who's employed by a business or a newspaper or whatever, depending on what the situation is, then copyright would be with them. So for example, if we had, I don't know, a photographer that's doing works for us, for the university, if they're employed, so if Claire is going around taking pictures for something at the university, and she's doing that as part of her job, then the copyright in those photographs will be with the university, as long as that's part of your job. Claire, we're pretending now that you're doing that for the university, yeah. So then it would be on the university to decide what will happen with those photographs. Now, the fact that the photographs were taken in 1930s would only be a key cutoff point if the person died in that year. Otherwise, the length of protection in photographs, there have been, so with photographs, there have been different extensions as well. But usually the rule is life of the author plus 70 years. So it depends. We would have to go for those specific ones. We would have to go, and this was all in the UK, even for the photographs taken, they're UK photographs. So we would just have to trace back what was the system of protection for photographs back in the 30s. And then see if it's, no, sometimes, you know, it's like a research project. You go on a fact-finding mission, but sometimes there's something also called, we would have to look specifically into the rules around that, orphan works. So when we don't know who the authors are, there are specific rules around orphan works and how protection works there. And usually if you don't know who did the work, you would go with terms of protection from the date of publication. So it depends with those photographs, if they were made publicly available anywhere, and you can say that that was done in the 30s. So it would depend, but.
Well, let's put it this way, Metka, no one's objected yet.
And, you know, that's the beauty of things, that quite a bit of life happens anyway, creatively. I mean, even if there are lines that are sort of crossed, the tricky part comes when somebody gets annoyed with something you've done and then, you know, coming to you. But here, if there was a good faith effort done to sort of see who the photographer was, I think, you know, and I don't think the journal itself would mind reprinting sort of an acknowledgement or something like that, just to sort of.
Yeah, we printed an acknowledgement, but we didn't have express permission. So.
Well, I don't think there weren't any people going after you and saying, oh, you haven't acknowledged. But with photographs, funnily enough, in this country, one of the reasons why photographs are not included in the reporting current events exception. So let's say I'm writing a newspaper article and I would be, you know, I would try to use Claire's photograph to illustrate a point. I don't know, I'm writing about the royals and I want to take Claire's photograph to make a point about my article with the royals. I can't use photographs and rely on defense of fair dealing for reporting current events. Photographs are expressly excluded from that defense. So photographs do have that very particular awareness in this country that it's an investment that was made in that endeavor, and it was also tied to the lobby of, I don't think paparazzis have a lobby, right? So it's sort of whatever, the newspaper industry and how those photographs were deemed to be of really high value. So traditionally, here in this country, they're excluded from fair dealing defenses.
Metka, there's a comment from Julia. She says, for one of my projects, I'm using photographs of the 1910 flood in France as collage, etc. It's just purely for my university project, but I don't think I'd be able to post them on my Instagram.
I think it would be just worth looking into who, I mean, I don't know if this would really be practically an issue. Do we know who's the photographer of the 1910 photographs? Because what, we imagined that they were 18 years old. Oh, I'm getting into math. That could be a really big problem for, wait, so 1918. Ugh, no, I need to cancel. 1910, so that's 28. Let's say that the photographer was 18 years old when they took them in 1910.
Oh no, she says she doesn't know. Can't find them anywhere. She's been trying to find who the photographer is. So
I wouldn't worry about such, I mean, the good way always to check is that there has to be a source where, Julia, where did you find the photographs themselves? Are they, because I see here that they're posted on social media, because the only thing you would want to worry about is if a publisher actually has copyright in that. So sometimes with photographs, there might actually be a publishing house that has photograph and they'll actually be taking care of that. So if there's any way of identifying where those photographs come from, that would be the only way of just figuring out whether you still need permission. So again, Life Plus 70 sort of applies, but it depends. So even if the author gives away their copyright, the duration of copyright is still linked to the author, not how long, because otherwise you would have internal copyright with companies just never dying, do they? Okay, so I think there's a little bit of a chat, but we can always sort of work on those as case studies, you know, finding French flood photographs from 1910. So what does copyright? So we had the exclusive rights. Who are they given to? So if you're the author, and the author being the person who has given the original contribution to the work, so it's the work itself is the author's own intellectual creation, then the first rule is that the author is also the first owner of copyright. The only exception to that rule is that if you're employed, as I was alluding to before with Claire taking photographs, so if you're employed and you are creating works as part of your employment, then the first owner of you are still the author, but the first owner of copyright in those works will be the university. So the classic example of that is me giving lectures as part of my contract or part of my job. I teach at the university. So when I give a lecture, even though those lectures are now all recorded online, as literary works, they're protected by copyright, but I am not the owner of those lectures. I am the author. The owner is the university because I am creating those lectures as part of my job.
Oh, sorry, I'm on mute. So if I'm making work for, as part of a project for someone, and I'm being paid for it, do that, so they would own, would they own it? I don't know, I'm confused.
No. So it's an excellent point. And so terms of employment are terms of employment. That's not every contract, and it's not every commission contract, and it's not every commercial contract, right? I'm employed by the university. I'm not employed for any consultancy I do, right? So that's the first bit. Now, quite often for commissioned works, you might have a provision in the contract whereby it will say that the copyright will vest into the whoever contracted with you to create those works. So that's where you need to start reading that contract to see who will have copyright. But in terms of just automatically under the law to happen, you have to be employed. And not only that, you have to create the work during the course of employment. So it's part of your job description. So, you know, I'm a law lecturer, and if I now write a beautiful song, that doesn't mean that the University of Wolverhampton will have copyright in that song. It has nothing to do with my job. Or in the same way, even if I write books, I still have copyright in those books because I'm not employed to write books. Yes, I'm assessed on that and it's part of my research profile, but that's not my job. Right? Again, a very traditional example is when you have creative talent working in ad agencies, and they'll be creating all sorts of material, visual and others as part of the ad campaign. Those materials, the copyright will vest into the ad agency. because that's exactly what they're employed to do. If it's just a commissioning contract, then it depends on the terms of the contract.
And if there happens to be no contract, then I guess.
But then you're in really murky waters, because
Yeah.
you have certain things like what was implied in the contract. So if you don't have a written contract, then should it ever come to a court, the court would try to understand what the parties intended to do. What did you mean to agree to? And then when you try to explain, well, I thought this would be the rule or this would be covered, does the other parties agree with you? If they don't, and usually once you're in a dispute, they won't, then it comes to certain things have been said, but certain things the courts will also imply into the contract. And often we've seen that the term or transfer of copyright has been implied. So things like if a company came to an artist and said, write me a logo for my trademark, there, even if nothing was expressly said, again, it would be open to interpretation, but the court would likely say, well, it's been implied that the transfer of copyright will happen because, you know, the company is registering that as a trademark for their external eternal use. So it depends. Best way, because if you don't have a contract, you know, will it ever go to court? That's very expensive. It's very terrible to have those conversations around, you know, what did you mean? What did you mean? What did that part of the email mean? You know, were things said, were things not said? It's just.
So the bottom line is get a contract.
Yeah. I think so. I mean, I don't know if that's part of the art. I know you have different types of courses, right? And you will have courses around how to value your work or how to position yourself in the world and how you do things, right? But, you know, for certain things, it's probably also worth, if it's a really big deal, just get some legal advice as well, you know? Just like you wouldn't just operate on your own teeth. You would just go to a dentist, right? So there are certain things and perhaps certain situations where you might want to just take a little bit of legal advice as well, if it's a big contract. But any contract, even if you're just doing some work for your friends, you know, there might be a situation where you're not going to be friends anymore, and you will want to know what will happen with your artwork.
Yeah.
When I was on my pre-diploma course at Colchester, I remember at the end of the course, they told us that everything that we'd done at the college belonged to them.
No, sorry.
So they wouldn't let us take any of the artwork that we display.
Right.
I managed to persuade them to give me a couple of things, but they kept everything. How about that?
They even allow you to take copies or pictures for your portfolio, or did they just sort of complete?
Oh, no, we take copies, pictures, but all the stuff we put in our final show,
yeah,
no, that's ours.
See, but that was just abuse of their position, wasn't it? I mean, we all can agree that. I mean, I don't know. I haven't seen a rule even at this university saying that, you know, all the work that's created by the students will belong to the university. I mean, that would be a very, very harsh rule. But,
yeah. Well, I was 18 years old. What did I know?
Yeah. Well, everyone in the audience, hopefully you're listening to this. Yeah. So we are sharing you these things so that they don't happen to you. And, you know, people sometimes say, oh, but I don't have money for a lawyer. Well, at least speak to your lecturers in School of Art. Speak, is this common practice? Is this how things are done? Speak to your colleagues, speak to your friends. You know, have you ever seen something like this written in the contract? Try to rely on each other as well when it comes to these things. I mean, I don't know how you would say, Mac and Claire and Rachel, if Rachel is still in the background, cameras off. Any tips on that for everyone in the audience around handling contracts or things like that?
Well, if anyone's got any tips, they can tell me. I don't know. If you,
the main tip
what about
is,
you, Mac?
main tip is check what people tell you. Really.
I think that's the thing. The few ones that I've had to sign, you just really read them and just obviously question what the how they interpret things as well, because some of the terminology can be quite difficult, I think.
Yeah.
And also quite boring to read, kind of list of clauses. I remember skimming through one basically. So, you know, which is not a good situation to be in. So I think it's probably taking the time to have a look.
And as you say, Metka, in that circumstance, if you do find the terminology difficult, get legal advice, I guess.
Yeah, because there are certain things that are important enough for all of you to sort of just get that as well.
Oh yeah, okay. So there's a question. There's a question from Jim. He says, "I thought the university had a right to use your images, not necessarily to have copyright."
Sorry, Claire, can you just repeat, because I was reading notes from
Katrina.
Oh, yes, sorry.
So Jim says, "I thought that the university had a right to use your images, not necessarily to have copyright, but to use them."
I think there is a provision around perpetual licenses, because we don't want to come into difficulty of, you know, somebody coming after us if we wanted to share. I don't know, you upload things to Turnitin, you have it on Canvas. So I think it's for those assessment type reasons that there's a perpetual license when you put in work for assessment. I don't think it applies outside of assessment terms.
Right, okay.
But I haven't studied in detail. It's how I see it from what we see here when we have assignments and things like that. And when students write dissertations, I see that there's like a statement there, and it goes to, oh, you give out basically perpetual blanket, you know, worldwide license for this dissertation. So I've seen that written there. I would sort of suggest that this is something that, you know, I would look at very carefully if I was an art student and I'm actually producing something different to a law dissertation. But yeah, I don't think it's a transfer of copyright. It would be just perhaps permission to use, so that there are no difficulties if the university is using these, even as, I don't know how you use each other's artwork for student purposes. I mean, because there are GDPR restrictions as well. So I know that we don't just share everything everywhere, especially not without permission, I don't think.
So when you've written your PhD thesis, and then I suddenly decide one day I'd like to publish it as a book, I have the absolute right to do that. I don't have to ask the university for permission to do
I didn't. No, so you don't have to, no, of course not. I think the only thing that's worth looking into is that universities sometimes have things like open access and those kind of policies. So for me, I needed to ask for, there was a form. I did my PhD at Queen Mary. So there was a form I needed to tick off for an embargo. And that I think was for 2 years or something, so that when I was talking to the publisher, there was nothing out. I mean, always the PhD thesis is different to the actual book that sort of comes out of you. It needs to be written for a different audience and everything. But just to sort of make sure that your publisher is not in a situation where there's something very similar that people can get for free from the British online sort of database, it's maybe just worth looking into sort of ticking a box for embargo if you know you have plans to publish. But in terms of copyright, you don't have to ask anyone's permission, because again, you don't transfer copyright, especially with PhD work. Yeah, absolutely.
Just going back to the university's right to sort of use your images. So it could possibly be for publicity or promotional literature. I mean,
again, I don't know, you know, when but probably it's because I'm, you know, in IP, I'm always so careful to know the rules of people's work and how I use it. So for example, the artwork we did with Michaela, so the women in law artwork that she sort of did for us after the competition and everything, you know, we've had a clear chat that, you know, yes, we want to use that in all of our promotional work and all of that, but at the end, I think copyright is still with Michaela, or, you know, just have that conversation, ask for permission, ask for everything. Can we put that on social media channels? Can we do this and this and this? So I think, you know, there's a difference between the university. Well, if the university does use certain parts of students' work, I think, you know, at least asking for permission would be something to because I know that all the photographic material is always commissioned separately, right? You don't just go around taking pictures of people and then putting them in catalogs. For personal reasons, for privacy reasons, for ethical reasons, you know, that's not how it's done. So I suspect with artwork, he would have, I mean, probably it's different if you take pictures of the art degree show. There you would probably, that's something that I would expect the university to have the right to do. And I remember there were these very, very posh catalogs from the MA degree show. Looked really nice, but I'm sure that's something that's expressly dealt with your students, right? How that booklet is reproduced and done or not.
Yeah, I mean, usually it's the students that kind of put it together. So I guess that kind of covers that.
I know, Claire, did you exhibit at the exhibition in Sutton Coldfield?
No, I didn't.
Well, I put a piece in there, and I came in, and Christian was doing some sort of video interview, and he used my piece as a backdrop to the video.
Oh, right. Okay.
He didn't ask me if he could, but he did anyway.
So how did you feel about it? You didn't mind, okay.
Quite flattered, actually.
Yeah, it's a tricky one, isn't it?
You know, I think as long as people don't mind, it means that then they implicitly give consent. But the problem is always knowing, you know, what happens if you do mind. And that's the last bit we're going to do with the moral rights. You know, how far can you go? And unfortunately, here in the UK, there's very little you can do if other people sort of, you know, refer to your work and do your work. And if there's no economic rights infringement. So, for example, if somebody sort of you know, a company were to buy your work, and then all of a sudden they sort of start promoting, I don't know, a particular political leader you might not affiliate with, and your work is plastered all across, I'm not going to name the leaders, i.e. this being on YouTube, but you can imagine. You might not be happy about that. And yes, you've transferred copyright, but what about your moral rights? Can you object to your work being associated with a political message or with a worldview? You know, what if your work suddenly gets, you know, used in a climate change deniers campaign or something like that, and you might, you know, all of a sudden think, well, actually, I'm really unhappy with that use of my artwork, right? So what can you do about that? So it gets tricky here, you know, if you look at the rights that artists have, it's not ideal, I think, in this country, in the UK. Yeah.
That's interesting. I came across an example of that with some friends of mine who are Morris dancers, and they were booked to dance at a fete, and they found out afterwards that the fete was actually organised by the National Front, and so they were actually dancing at a fete that was a specific expression of the National Front's view of national identity, and they were upset about that. They were.
So did they try to get away with it and couldn't break the arrangement, or was it too late for them? So by the time they were already there,
late. By the time they realised what they were doing, who they were doing it for, rather, too late.
Now imagine that, you know, that performance is then recorded and put online, you know, forever and ever.
Yeah.
You would want to have a right to do something about that, right?
Yeah.
I don't know what came of it, I'm afraid.
Yeah, you know, I always make up those scenarios when I'm writing exams, but it's not. It's actually something that can happen and does happen quite often to artists in real life. So, yes.
Yeah. Just an amusing version of that is another friend of mine who was also a Morris dancer. His team was booked to dance at an event, which turned out, this was some time ago, this turned out to be organised by the Ban the Bomb people. My friend happened to be one of the foremost rocket scientists in the UK, and he said on the morning after this had been shown on the news, on national news, he said, MI5 or what it was, rang him the next working day and said, "Why were you dancing at a ban the bomb demonstration? And you're one of our top rocket scientists." And he said, "Yeah, it was funny, wasn't it?" And that was the end of the conversation. Yeah.
Yeah, it's quite surprising how sometimes you're completely unaware of, or, you know, some things are just not disclosed to you or with you. Oh, you know, you'll get the number or the size of the audience, but they will tell you no more than that. And it's only once you're there, you're sort of like, hello, and you go, oh, what can I really pull out at this time? So yeah, it's not great. But if we do sort of just see here, so this is just, I'm not going to be really this is just to make everyone aware, so all the visual artists in the room, that there is such a thing called artist resale right. So it's the historical remnants of droit de suite from France. It's much more, it has much more content in European context, but it does exist in the UK as well. And there's some further links there. So you can just sort of Google search it, artist resale right in the UK, and the government website comes up and it has a detailed guidance, but it has to do with artwork being resold through an art market professional. So that's one of the requirements. And then I guess you have that, right? You will both know whether artists will be encouraged to sign on the collective societies, so Design and Artist Copyright Society and Artist Collecting Society. Is this something that's looked at, or no?
No, not to my knowledge, no. What about you, Mac?
Not heard of that.
Not heard of that.
No.
So, I mean, we can sort of look at this in any further detail if you want. I'm just sort of aware of the time, but we can sort of look at this with Claire and with others in more detail if this would ever be of interest. But I just, you know, that's something that I always kept in my mind. You know, it's so important to be aware of this. So even if your work, you know, you're a budding artist first, and then 10 years after something's sold for big bucks, as they say, through an art gallery, doesn't mean you sort of get robbed by it. I like Rachel sort of, yeah, big bucks, sure. You know, should that ever happen, you know, just to be aware that there are certain percentages of the sale that you're entitled to, and those get paid. So this is managed collectively. What we mean by that is you register with the society, and then they distribute these sort of funds and everything. So it's Design and Artist Copyright Society and Artist Collecting Society. I mean, I'm more familiar with the ones in the music industries, but I was aware of the droit de suite, but then sort of when I was just going through the details for this talk, I did see that this is managed collectively. But we shall just make it sort of a point of awareness right now, and then we can explore if of interest or if needed in something further. Because I do just want to, in the last few minutes, just want to touch on moral rights, right? And literally, I'm going to do that in 2-3 minutes. So I always like to have these kind of pictures, you know, moral rights, you know, how could anyone ever be, you know, insulted, or where would they be engaged? Obviously, Mona Lisa is no longer in copyright, so people can do whatever they want with the painting, right? So this one will probably qualify as a parody as well, maybe potentially, yeah. But even if not, you know, it's in the public domain, so people can use it. So what are the moral rights? So copyright, the economic rights, are given to the owner of copyright. So the owner is either the author, or we saw if you transfer copyright as an artist, then somebody else becomes the owner if you transfer, or with employment situation, you might be the author, but the first owner of copyright might be your employer. So copyright economic rights are given to the owner of copyright. Now, all authors, even if they transfer copyright, or they haven't been given copyright in the first place because they're employed for that particular work, will have moral rights. So moral rights belong to authors of works. And we see sort of the definition. So it's to the authors or directors when you have films, but that's not relevant for today. What are they? They're quite limited, but they go to you having the right to be named as the author, so the right of attribution, and also the reverse of that. So if somebody is falsely attributing work to you, you can object to that. So you also have the right to object to false attribution of the work. Limited right to privacy in certain photographs and films. Again, that's sort of a very limited right. But the one I want to sort of touch, and that's exactly what we're talking about with the dancers and everything, is the right to object to derogatory treatment of the work. So that's found in section 80. There are several steps to go through, but in the UK, this right of integrity or the right to object to derogatory treatment of your work is limited to physical interference with the work. So my Mona Lisa example is when you plonk a cat in Mona Lisa's lap, that's physical interference with the work. Yeah. If you change the pixel density, if you change colors, if you make a black and white picture, a color picture, all of those kind of addition, deletion from, or alteration of the work, those would be covered by this right. What is not covered is this recontextualization. So what we were discussing a little bit, or, perhaps I was alluding to these kind of examples. If your work is used, your artwork is used in anti-climate change, so climate change denier campaign, or your work is associated with a particular group that, is very misogynistic, or whatever the situation that goes against the artist's conviction, then unless there was a physical interference with the work itself, you will have difficulties in stopping it. So once you've transferred your copyright, so copyright is still the best way to control your works. If you've transferred copyright, you still have moral rights, but then in the UK, they're very limited. So you have to have physical interference with the work. And there is a separate requirement as well. And that is to do with that the treatment of the work has to be derogatory. Now, unfortunately, here in the UK, the standard of what will be deemed to be prejudicial to authors' honor and or reputation is an objective standard. So what a regular person in the street would think is, prejudicial to honor and or reputation, not what the artists themselves would think is derogatory or prejudicial to honor and reputation. And this is, again, it's a UK position. You have other systems like France and Canada and others where the standard is subjective. So if the artist is offended with what other people have done to their work because it interferes with their creative or artistic message or their worldview, they'll be able to stop it, not in the UK. So the UK has moral rights, but they're limited. And we also see that not only by exceptions, but by the rules around waiver. So it's possible in this country to give away your moral rights, and not only to give away the existing rights, but even if you have an open contractual relationship, let's say with university or a particular entity, gallery, whatever, you might even give away your moral rights for all future works because the contract is written in that way. This is not possible in systems like France, where moral rights are considered to be human rights because authors and their link to copyright to their works is deemed to be very personal, integral to who they are as people. But in the UK, we don't have such status for moral rights. So they exist. They are the right of attribution, the right to object to false attribution, and the right to object to derogatory treatment of your work, but they're very skeleton rights.
That's interesting. Anthony Gormley, the sculptor who made the Angel of the North, he recently objected to someone who had some of his work and decided to, I think it was installed on a beach anyway, but what this person did was he or she laid them down on the beach because felt people didn't want to trip over them or something, and displayed them in a way that Gormley didn't intend. And apparently Gormley was very incensed about this. But I think the outcome of that was that there was nothing he could do about it anyway.
I mean, I forget the artist's name, but in Canada, for example, one of the artists created, and they've created the work for one of the malls there. They've created a flock of flying geese, white geese, and that was displayed in the mall. And what the owners of the mall wanted to do is put red ribbons for Christmas around the geese. And the artist went, "What are you on about? This is complete violation of my work." And they've actually succeeded with that claim in Canada. in this country, you know, you wouldn't even get through the door with a claim like this. In the US, you had another moral rights claim, and again, I forget the name, but the author was, so do you know the Wall Street, the bull, the bull in front of the Wall Street, the big sculpture made, I think it's bronze, and then the fearless girl, the little statue of a little girl that was juxtaposed across the bull in the Wall Street square. That artist of the bull, which in the 90s was sort of, you know, vision of freedom, free trade, and all of that, had very positive and sort of capitalist message. Come a few decades later, putting that little girl there who was there fearless and, you know, sort of had a superhero pose, it changed the message there and the dynamic. And the artist of the bull, the sculpture, which I think he's passed away just recently, but he's Italian, and he objected to this placing of the fearless girl. First, it was meant to be a temporary thing, but then they sort of tried to make it a permanent sort of feature. So this is how moral rights have been playing out in different contexts. But yes. Yeah, I do think that quite a few scholars would say that we need better moral rights in this country, but nothing's moving yet currently in the situation. So yeah, so I think even though we said we're not going to use all the time, I've been blabbing on.
Oh, yeah. It's just so useful though, isn't it? You know, I think once you start talking about one thing, it just leads on to other stuff, doesn't it? I mean, one really useful thing that Katrina's put in the chat, just in case nobody's seen it, she says many specialist IP lawyers or law firms will give artists and students 30 minutes or so free advice, or provide you with information sheets. So I mean, that's really useful to know. I mean, I didn't know that.
I mean, we're always trying to also here at the university, and also, you know, there's always, so I do with my law students, I have something that's called the CFC live cases, and they sort of work with different artists and different businesses. It's not professional legal advice, and we don't pretend to be solicitors, but we can just sort of maybe signpost to sort of relevant pockets of law and things like that. I think there are certain key lessons that you learn very quickly and easily just by talking to other people who've perhaps seen a thing or two. Yeah. But, you know, it's sort of, yeah, that's the extent of it. I'm just trying to stop share.
All right. Thank you, Metka, again, just for sharing so much knowledge. It's absolute gold.
It's my pleasure.
So thank you. And we really look forward to the next session, which again, I'll just say is on the 25th of May. So please do book. It's free, as always. We do also have an ArtsFest online event tomorrow, which is a webinar on the rise of photographic illustration in 1839 to 1880. So if you're interested in print and print history, that one could be for you. And again, you can book for free through Eventbrite. So I hope to see you all there. Thanks for watching, and yeah, see you soon. Bye.
See you soon. Bye.